Columbia University.
I'm Paul Rissman of Rights CoLab also, and also on the board of the Sierra Club Foundation, and also this year I'm an Open Society Foundation Fellow.
And I'm Charity Ryerson from Corporate Accountability Lab.
Are you hearing me now? Am I mic'd? I'm coming up. Okay, great. So in the past decades, the human rights movement has been grappling with this, the contribution of powerful actors, private actors, namely corporations, to human rights harms around the globe, and how to hold these corporations accountable. And what we're seeing is this manifestation of global capitalism, of these vast, complex organizations spanning the globe with their supply chains, their complex structures, these multiple tiers of suppliers, subcontractors. And as a result of some of that, we see recent disasters that are continuing today. So examples are the Rana Plaza disaster, the falling of the major factory complex in Bangladesh due to its insecure structure, which had been actually audited by a number of respected auditing agencies not that long prior to its collapse in 2013, killing over 1,000 people, were mostly young women workers. The catastrophic failure of two tailings dams in Brazil, one in 2015 and then one just at the start of this year. Both Vale, the corporation Vale's company projects. We've talked already at this conference about Facebook, fueling of violence around the globe, including Burma, and election interference, its involvement in the manipulation and election interference. In addition to these more well-known cases, there are really every month, every year, tens, even hundreds of cases of harmful impacts of companies operating around the globe, including and in particularly harming the most vulnerable communities, indigenous communities, migrant laborers in manufacturing, in agribusiness, in construction, and all of which is documented regularly by the media and NGOs.
And particularly women.
And in particular, women. So we have to ask ourselves, how do we continue to grapple with this? What do we do about this? And the answer to these problems of corporate impunity fall along a spectrum of holding corporation legally accountable and finding in a court of law, and finding ways to hold them accountable in the court of public opinion, through markets, through and to punish these private actors. So like many others in the field, Charity, Paul, and I have been trying to, individually and in our own separate ways, thinking through why do companies continue to operate with impunity? How can we close the governance gaps? And we've landed in somewhat different positions, and we wanted to use the opportunity of being here to have a conversation about the different places that we have landed that we feel are sort of less explored, underexplored areas of corporate accountability. And that's what we want to share with you. Charity, would you like to talk about your how you come to this issue.
Yeah, thanks, Joanne. So, when we talked a little bit before we organized this panel, we started to think about how our own careers in some ways highlight some of the important movements in the corporate accountability space over the past 20 years. I got started in the student anti-sweatshop movement, so folks might remember in the late 90s, early 2000s, people started talking about Kathy Lee Gifford's sweatshops with child labor. There started to be some exposés, and this idea of human rights and global supply chains sort of became more common knowledge than it had been before. They started to develop codes and monitoring at that time, and that was kind of the primary strategy. So as a student anti-sweatshop activist, I got to really get into what are these dynamics? How do we exercise pressure as global North people, whether through our identities as consumers or students or anything else? How do we exercise pressure to impact particular worker struggles or human rights struggles in the global economy? From there, I started working in labor rights monitoring in Latin America. So it was sort of a monitoring and worker solidarity combo. So I was doing worker organizing with flower workers on plantations in Colombia and banana workers in Colombia and Guatemala. I investigated anti-union violence cases. And there we could see we were working really closely with all of these workers that were struggling against US companies. They were producing for the US market. And then we were trying to mobilize consumers on the US side to say, can you all write letters to X company and tell them we're going to bring this worker on tour, we're going to demonstrate so that people can really see and feel the problem, even though it's very far away. And we found over time, or at least I found and ultimately concluded, that there's certainly a role for consumer activism, but it's not enough. The structural problems are so severe that consumer activism might cause some shifts at the margins. But for the amount of resources that were dumped into this project, it wasn't causing us to prevent anti-union violence cases. It wasn't getting any remedies for those widows of the banana workers, nor was it resulting in a union that had been busted getting all of their leadership rehired. So we weren't able to get those kind of concrete asks addressed. So I started to look at the Alien Tort Statute cases, which at the time, in 2007, 8, 9, there was a lot of these cases filed in federal court against big US, global North, European companies in the United States, trying to say, well, if you violated human rights overseas, but you're based here in the US, this can't be a safe haven. So we should be able to sue you where you are at home. I started working on those cases even before law school. I worked in the Zona Bananera in rural Colombia for a while with Chiquita plaintiffs. When I graduated law school, I did alien tort statute litigation for a few years, looking at this as kind of the primary mechanism for access to remedy for victims of really egregious human rights violations in global supply chains. In 2013, while I was still doing this, the Supreme Court issued a ruling in a case related to the Niger Delta that really shut down the Alien Tort Statute as a tool for human rights where the rights violation occurred outside of the US. So that was the sort of limitation of the extraterritorial application of the ATS, if I can use a big word like that. We also saw a limitation of the torture statute that we were using, so it could be used against individuals but not corporations. So we saw this world of sort of limiting access to legal remedy. And so in 2016, I quit litigating. I started in 2017 Corporate Accountability Lab, really focused on how can we start looking at commercial law? How can we think about where are the mechanisms for corporate accountability that we can find that don't lie in human rights law, because companies are replete players in the system, and they can undermine human rights law systematically over time, but they can't undermine contract law and intellectual property law and international trade law. How can we turn those areas of law back against them for human rights? So I started CAL really to do that. But maybe I want to pass it over to Paul, and he can tell us a little more about his background and how he comes to this work.
Thanks. Well, I was minding my own business as a retired money manager until the presidential election of 2016. And then I got stressed out and decided to try and do something. 2 of my 3 kids were environmental activists at the time and wanted to, and they influenced my actions. When I was working for a large money manager, I was always very impressed with how important I was. I was always wondering why these CEOs would be spending hours of their time with little pipsqueak analysts like me. Companies really care about their investors. and they listen to their investors, and they allow their investors to influence them. And so I, as an investor and as an insider and as somebody who sort of knew the ins and outs of this very subtle and very sprawling and very complicated industry, I decided to sort of lend my hand to activists who are interested in engaging with companies, don't really know how, interested in engaging with investors, and don't really know how the investment landscape works. And so since that time, I've been engaging with investors and with companies as an investor and as an advisor to investors. And that's what I continue to keep doing.
So I have been teaching and researching and thinking over the past 2.5 decades about how to make human rights actionable and relevant to all rights holders. And in the last 15 years, I have been working in the business and human rights or corporate accountability space, and I've come to certain conclusions after working in the space for this amount of time, and one of those being that the business case, this idea that companies can only take action to prevent human rights if it can benefit their bottom line, that this really isn't gonna hack it. That it's just not strong enough, no matter how hard we try to make it so. And without government action, corporations are really programmed to prioritize profits at all costs. And so my innovation comes from that desire to be thinking beyond the business case. So we have, I think all three of us have different approaches. We may see some things a little bit differently, but we're looking forward to sharing them with you. This style of our presentation today is really a conversation. It's actually inspired by a podcast, my favorite podcast, called Capital Isn't. I don't know if anyone is familiar with it. But it's two economists who talk back and forth to each other and explain economics in really interesting ways. So we're going to try to do that. We're going to have a conversation for the next 45 minutes or so, and then open the circle and invite you to be part of that conversation. So where do you all want to begin? I think we want to kind of lay out a bit about why we think corporate accountability has not the attempts at corporate accountability kind of have not actually gotten us where we want to be, and why we're still feeling that lacking. You want to
Well, that sort of necessitates that we lay out the kind of the history of business and human rights in a very brief synopsis, which you are the best equipped to do.
Would you like me to do that?
Why don't you tell us about the history of business and human rights?
Well, how many people are familiar with the UN Guiding Principles on Business and Human Rights? Okay, most of you. For those of you who do not know, there's been a very high-stakes debate going on within the UN about this question of how to hold corporations accountable. And that was inspired by really decades of a movement or harms that began, let's say, in the 1960s with Dow Chemical's production of napalm in Vietnam and the activism on campuses around that, leading into the Nestle baby milk case, which actually is a campaign against the Nestle's marketing of baby milk products to poor women in developing countries, and sort of an aggressive marketing that had them using baby formula that would be mixed with sometimes contaminated water and cause illness in their baby. So that was a debate that continued to Bhopal in the 1980s, 1984. And then in the 1990s, we saw a series of cases involving extractives companies, Shell in Nigeria, and Chevron in Ecuador, Unocal in Burma, and also a number of incidences around, that many of you may remember, around apparel and footwear supply chains, Nike being the most prominent example. So all of that stirred the business and the human rights movement to say, we need to take action. A process began in the UN in the late 90s, and eventually gave rise to a mandate under the UN Special Representative, the UN Secretary General, called the UN Special Representative on Business and Human Rights. It was John Ruggie who was appointed to that post. After a 6-year, 2-term mandate, he developed, what came out of this was a UN Guiding Principles on Business and Human Rights, which were unanimously endorsed by the UN Human Rights Council. So in that sense, have become the most authoritative standard. And the UN Guiding Principles have 3 pillars. The first pillar is the state duty to protect, which means that the state has a responsibility to protect against harms, even those harms, including those harms caused by corporations. The second pillar is the corporate responsibility to respect, which means regardless of whether the state actually fulfills its duty to protect, corporations have a responsibility to respect human rights. And the final pillar is access to remedy, that those victims of human rights harms will have access to remedy.
So did that stop corporations from committing human rights violations?
And it did, well, clearly has not, but there has been some progress. So what we got out of the UN Guiding Principles was this recognition that indeed corporations have human rights responsibility. Today, most major corporations have human rights policies, which is a self-admission of having those responsibilities. We see that the UN Guiding Principles have been incorporated into standards. The International Finance Corporation, the private sector lending arm of the World Bank, has performance standards that have incorporated the UN Guiding Principles because so many private banks are client banks of the IFC. Those banks also that have formed, there's some 80, 90 banks that have formed the Equator Principles, have decided to also adopt the IFC performance standards. The UN Guiding Principles having been incorporated into the ISO 26000 standard on corporate responsibility that came out shortly after the UN Guiding Principles were developed. And we have other ways in which the OECD guidelines for multinational corporations incorporated the UN Guiding Principles. So we're now actually seeing the UN Guiding Principles being worked into hard law standards, particularly in Europe. And I think that there has been progress in terms of retraining a focus on rights holders. So we've definitely gotten somewhere, and it has also spawned this active human rights movement and business and human rights movement. It is now a field, it's a movement. There is scholarship. There's a business and human rights journal published by Cambridge University Press. So we've made progress, and yet.
May I?
Yes.
I think you said something that I'm interested in. That the guiding principles are being incorporated into hard law in Europe. And there was a recent series of a little flurry of activity regarding that, which has just come to light in the last couple of weeks, which Charity knows about.
You mean here in the US or at the 307?
Well, there's the French, the companies are being sued in under the French law of vigilance?
Yeah, so there's a few, I think the UNGPs, maybe going back to complement something that Joanne said, the UNGPs do create this really useful analytical framework, and one of the things that they really lift up is due diligence. What is the expectation on companies to find out what's happening in their supply chains all the way down? And I think the historical position has been, I don't own that factory, I don't own that farm, it's not my responsibility. And now we're in this movement toward, I might not own that factory or that farm, but I might still be responsible for it in some way. And I think there's just from a sort of incentives perspective, it's really important to find ways to make sure that companies do have accountability all the way down the chain, because they're setting the standards that create the environments for those abuses, right? You think about a company who wants to order 1,000 t-shirts, and they go to the factory owner and they say, okay, I want 1,000 t-shirts, I want them in a month, I want these quality standards, I want it to be this color, and I want to pay this price for those t-shirts, which is very low. P.S. abide by my labor standards. And the factory owner is going to say, I have a 1% profit margin, whereas the brand has a 30% profit margin. And the factory owner says, something's got to go, and it's going to be the labor standards, right? This is what we call the squeeze. So there is this idea that companies, even if they don't have right now real legal liability for what they do all the way down their supply chain and for that due diligence, they are creating the problem that leads to these kinds of abuses. So with this, in Europe, they're passing these laws now, these due diligence laws. There's various proposals. The French law is the one that's gotten the most attention because it has, there's been a few cases filed under it, which is exciting. But this is a law that actually creates legal liability for due diligence in supply chains. To what extent are companies actually taking all of those steps to make sure that basic human rights are complied with if they're going to be importing those goods into Europe? And we similarly here in the US have a one particular very narrow customs regulation that has not been used very much, but it does prohibit the importation of goods made with forced labor, which includes indentured child labor. So that's something that just recently in the last few days has been used.
And that's what's interesting, is things are constantly changing.
Yeah.
And the last few days, in the last week, there's a constant change. I might show now a slide that I use when I teach business and human rights. I may not have mentioned, I teach business and human rights at Columbia University. And I kind of frame, I don't know if you all can see this, but I frame the course around this idea of the web of corporate accountability. And this probably would have looked very, very different in the early 1990s. So here are the pieces of it. There are various vectors. And the first one, or one of them, is corporate self-regulation in the form of human rights due diligence. Because until this new law, and it's very new, 2017 for the French law, it has been voluntary for corporations. And so, again, that's where you're pushing everything through the lens of that business case. And then there is government regulation. And that's the kind of thing that we're all expecting, right? Governments, can't they regulate this? And again, through the first pillar of the UN Guiding Principles, they're called to do so. There are hybrid forms, what I would call hybrid forms between corporate self-regulation and government regulation in the form of these multi-stakeholder initiatives. So they're sort of private, voluntary initiatives in which groups of companies join and agree to a particular set of standards. And those standards may have accountability mechanisms or not. And then there is, I'm having a hard time seeing where I go next on that. Regulation by, thank you, by capital providers. Thank you. So I've actually switched things around because I had a student, we just added a new one this semester. But regulation by capital providers, which Paul will talk a little bit more in about a minute, but it's the idea that those who are providing financing to companies have choices to make about what kind of companies they want to finance. So we're seeing increasing screening, what's known as ESG investing, investing along with environmental, social, and governance criteria. And then there's regulation, what I call citizen regulation. It's something that we're all expecting, right? The consumers are going to rise up and demand certain things, and through boycotts, their own purchasing practices, and other forms. And then a kind of what I might call a hybrid of those two, which is shareholder activism. And finally, the new sort of wing of this that we're seeing more of, which is employee activism. That's a kind of a new area to explore, but particularly in the United States. In the current climate, in the past 2 years, we've seen Amazon, Google, and other companies have employees who have been taking action and demanding certain things of those companies. So this is I like to call it the web of corporate accountability, because it is a web, right? And so sometimes with all these developments, sorry about that, we're seeing a kind of a closing of, or we feel like we might be seeing a closing of those gaps, and then sometimes that web is becoming bigger and those gaps are still there. And it's really addressing those gaps and sort of wondering how we're going to get a greater closure on that, which is causing us to think about some of the innovations that we are working on. And Paul, I feel like passing that on to you, since I just raised the whole question of financial actors and financial actors holding corporations accountable. I know you have some thoughts on that. Why don't you jump in?
Yeah, so shareholder primacy is this corporate governance doctrine that states that shareholders are the most important constituency of managers of companies. And of course, this means public companies, because private companies don't have shareholders. But public companies are the largest companies in the world in general, so that's okay. And for a long, long time, the human rights community has looked at shareholder primacy as a bad thing. Because shareholders were just people who extracted profits and exploited other stakeholders being employees, communities, the environment, whatever. And that has all begun to change. So, for example, about a quarter of the assets in the United States are managed by people who claim to be socially responsible. Whether they actually are or not is less important than their claim, because their claim is influential. The companies have we've actually been seeing some change in companies. Investors have become very concentrated. So in the mutual fund business, for example, the 5 largest fund families, who are BlackRock, Vanguard, State Street, Fidelity, and Capital Group, they're under the radar. No one's ever heard of them, but if you have American funds, that's them. They control almost half of all the mutual fund money in the United States. So they own massive amounts of companies. BlackRock owns 3% or more of 2,500 companies around the world. Vanguard owns 3% or more of 1,800 companies around the world. So companies listen to these giant behemoths. And if you can get the giant behemoths to be more socially responsible, then they will impose upon the companies to be more socially responsible. And so we've seen a number of things. For example, we just saw one of the biggest natural resources companies in the world, BHP, which is an Australian company, dual listing in Australia and London. They have become the first company in the world to say that they are going to tie their executive compensation to the emissions that their customers produce. So that's very esoteric. It's called Scope 3 emissions. If you're doing stuff on climate change, you know about that. But companies have always said, we can't tie our compensation to what our customers do. We don't have any control over what our customers do. But they actually do have control over the customers do because they have control over what the products are that the customers buy. And so this is the first case ever, and it happened this spring, where a major multinational decided to tie their executive compensation to their customers' behavior. And that was because of shareholder engagement. Also, shareholders file shareholder resolutions. Nobody else can file a shareholder resolution except a shareholder. So if you don't own company stock, you can't file a shareholder resolution, obviously. And a lot of these shareholder resolutions, there's been a movement from an organization called the Center for Public Accountability. They are filing resolutions where companies have to disclose their lobbying expenditures and their lobbying strategies and their political contribution strategies, which is good because in Citizens United, Justice Kennedy said, oh, well, don't worry about it because shareholders will police the corporations. And so shareholders are actually starting to adopt that responsibility. There were a lot of shareholder resolutions this spring. Spring is shareholder resolution season. There were a lot of shareholder resolutions this spring about corporate lobbying disclosure. They get a lot of support. And that has been one of the things that has caused, the S&P 500, the biggest index of the largest companies, more than 60% of those companies, so 300 companies, now are disclosing something at least about their lobbying expenses, and they never did before. So corporations are actually being influenced by shareholders, and not for the bad, but for the good. And so what I'm trying to do is actually turn shareholder primacy on its head and make the shareholders be more responsible and even make them more powerful. And there's actually pushback now from corporations that don't want to make shareholders more powerful. So if you've heard about the Business Roundtable letter that everyone was going crazy about, where they said, well, we don't really want to pay attention to shareholders anymore. We want to pay attention to all of our stakeholders. And everyone thought that was a really responsible thing for the Business Roundtable to say. It's not, because they're feeling pressure to be more responsible from their shareholders, not less responsible. And so all they're saying is, we don't want our shareholders to make us more responsible anymore. And so there's a lot of exciting things going on, and that's what's happening in the shareholder accountability space.
So here's where Paul and I have some nice tension, because I think that's very exciting. And while I'm 100% in favor of pushing down there, I do continue to have a problem with shareholder value and this notion that the way corporations are structured today is to maximize shareholder value. And I think that there should be a fairer, more equitable, better distribution of economic value throughout to workers, to communities, and we're just not seeing that. And I think that is fundamentally what the problem is. You'll recall that earlier I said that a big problem that I have is with the business case. And I'm not certain that is going, that we really see are going to, that we're not going to hit a wall in that way. How far can shareholder pressure go? I'd like to see it happen, but my project and what I'm interested in looking at is and interested in watching is the proliferation of alternative corporate forms that bake corporate purpose into the corporation, where it's not just lip service of the Business Roundtable, but in fact that corporations are structured or have renewed charters to put the purpose of the corporation front and center. And so you know, these are not, it's a little bit, these are, you know, when we're talking about alternative corporate forms, what are we thinking of? Well, we can start with some forms that have been around for a very, very long time, like cooperatives, or which is apparently, the statistic that I've seen is about 12% of the entire population of humans in this world are in cooperatives of one form or another. And just in the United States, there's a total turnover, annual turnover of 2.1 trillion in cooperatives. We also have,
Who's the biggest cooperative in the United States?
who is it?
Publix supermarkets.
Publix?
Yeah. Anybody shop at Publix?
Publix is a co-op?
Yeah.
They were targeted by the
Immokalee
Yeah.
workers, I was just about to say.
that part.
So I'm not putting all my eggs in the cooperative basket.
Nobody's perfect, I guess.
I'm starting, okay, so, and we can say the same thing about ESOPs, employee stock ownership corporations, which are now, and in fact, in doing a little research, I found out that there's more ESOPs here in the Midwest than any other part of the country. It was very interesting to learn. But they have total assets of 1.4 trillion, and I think that there's great potential there. There is also a new form, a relatively new form, called the benefit corporation. And the benefit corporation is a way in which that we have, I think it's 26 or 30 states now in the US that have legislation that allow you to register as a B corporation as opposed to a C corporation or an S corporation, and the B stands for benefit. So you need to show, and again, the laws state by state, they vary, but you need to show and have in your charter a statement of general public benefit, and then some states optionally also have specific public benefits. And the purpose of this is to show that you will have like broad benefit, that there isn't going to be an offsetting of something good being done in one place and something then harm in another. So you have to have general public benefit. And that essentially locks corporate purpose into the corporation, so that you cannot be sued by shareholders for not maximizing shareholder value when you are fulfilling the purpose of that corporation. The nonprofit B Lab has created an assessment standard, because you're required under this legislation to report, and so the nonprofit B Lab has created an assessment standard called the B Impact Assessment. If you score an 80 or above on the B Impact Assessment, you may become a certified B Corp. And there are about over 3,000 certified B Corps now and growing. And so that's another way to build purpose into the corporation.
May I jump in and ask you about that? So there are 3,000 B Corps, but I believe there are only 2 public corporations in the world who are B Corps.
Certified, well, yeah.
Yeah, certified. And the largest B Corp is a division of Danone.
The US subsidiary.
But not Danone itself.
Although there is an objective within the next 2
Right,
years.
so maybe they'll be the first large public company to be a B Corp. So what's keeping large companies from undertaking this certification?
Well, I think it's a hard thing to do. It's certainly a hard thing to do. I don't really have the answer to this. One of the critiques I have of the B Corp movement is that it has an ambition of scaling up kind of unlimited. There's no talk about the limits, the whole notion of limits to growth, but the limits to how big you can be as a corporation. And I think that the B Corp movement ought to take stock of the problems that have that have taken place because corporations have become too big to do human rights due diligence in many cases. And so this notion that you can scale unlimited and not do harm and fulfill your mission, I think is something that that benefit corporations need to take stock of. There are, by the way, benefit corporations that are also ESOPs. B-Lab has had a look at those, and those perform even better for workers, higher scores for workers, same scores for environment, so ultimately benefit for both. There's also but there are other examples, and just to name just one more because I think I'm going to name two more because I think they're really interesting, is Organically Grown Company is the largest distributor of organic produce in the Northwest. It produces 100 million pounds of produce, moves 100 million pounds of produce a year. It employs over 250 people. And it decided that it needed to develop a new corporate form. So it used trust law to create a perpetual purpose trust. And this was just last year. And so it bought back, it had been an ESOP, and it bought back all the shares from the employees. And it's a sort of a mission lock because they have as a mission to forever be able to treat their workers well and provide good quality organic produce and treat the farmers well and throughout. So this is a kind of a new experiment in a new corporate form. The second type that I want to raise, and when you talk about large corporations, what can we do? I know that you want to go here. What can we do to reform them? Kate Spade has a line called, I think it's In Purpose or On Purpose. And this line is supplied by a supplier in Rwanda, which is a women's cooperative, which is run by over 200 women working full-time with competitive salaries, benefits, 3 weeks vacation, paid maternity leave, sick days in their supply chain. So there's no reason why more large companies can't be thinking more carefully about the structures of their suppliers as a start. I think there's more thinking that we need to do. There is a debate, and you and I have debated about co-determination, having civil society stakeholders actually on boards, and the benefits and drawbacks of that, but it's another corporate form. So this is a growing part of our economy. The corporation, as it stands today, this maximizing shareholder value corporation that emphasizes profits, is an artifact. We created this. And I think if we look out 20, 30 years, there is no reason why we can't be building out these more and more these alternative corporate structures that better distribute economic value to workers and communities. And so that's the vision I have, and that's where I'm going.
Well,
and I wonder if in the interest of time, we couldn't, it's about 9:53. Maybe we should shift over to our next section.
Yeah, well, just to segue into that, it's difficult for corporations to voluntarily decide to reduce their profits, and therefore they might often need to be forced into that. Should be noted that Elizabeth Warren has proposed a federal law federalizing corporate charters, which would require all corporations to have a purpose, which is not the case now because corporations are incorporated in states, mostly Delaware. And so there is law afoot to do that. But in the absence of these voluntary movements, shareholder pressure is voluntary also, we have some hard law levers that can be pulled, which you are an expert in. So let's transition over to you, and you can talk about the things that you're doing as far as manipulating the levers of hard law.
Cool. Thanks, Paul. So one thing I think just to address is that we're talking about a lot of different strategies that all kind of play into this complex ecosystem of corporate accountability. And I come in on the sort of access to remedies side or legal accountability side. And I've heard the critique often that lawsuits and this sort of approach can be too aggressive, and think about how corporations, if allowed to do things voluntarily, can be much more surgical in their responses to these kinds of supply chain abuses. I think that's right, but I think that if there's no possibility of legal liability, then companies won't do that. So what you see in these voluntary initiatives is a total lack of efficacy with a lot of very flowery public statements. And so right now we're in this space where the gap between statement and action is massive. If there was the risk of legal liability, I think we'd see that narrow. So you'd see companies take much more concrete actions, and you'd see them focused more on impact rather than statements if they could actually be held accountable for impact. So the vision is not to have to sue every company every time they violate human rights. The idea is to create the possibility of them being sued so that they will address it in advance. Because we don't want this to stay in the CSR departments. We want it to shift over so that legal sees this as a liability. If the legal department sees it as a liability, that's going to go into logistics. That's going to go into the people who are making the real concrete decisions, and it's not going to stay where corporate social responsibility is essentially a PR exercise. So we're trying to marry those departments through litigation and having the possibility of real legal accountability. Could you go back just to our main slide, not my slide? Go back to just the first one and the last one.
All right, going there.
Just the slide with our social media.
I can't seem to get there.
Oh. I just wanted to quickly, before I sort of launch into what strategies we've been developing in our lab, go back to our slide showing all of our various Twitter handles. So I encourage everybody, we should have maybe said this at the beginning, to be tweeting throughout this and making sure that sort of the conversation is a little bit more public than just what's in this room. So we put our Twitter handles up there for you. Corporate Accountability Lab as a lab. Has anyone gone to any of the Just Labs workshops yet? A couple of folks. So this idea of using human-centered design for human rights is something that remains a little niche, but there's a few of us in there doing it. And in this little niche, we try to think about how can we really invest in innovation so that we're not stuck with a very limited and old set of tools. And that means that we come up with ideas and we test them in the most limited way that we can. So within our lab, we always, we've got a bunch of law students and lawyers. We've got our brain trust of commercial attorneys who contribute. Someone comes to us and says, what about that mafia racketeering statute? Could we use that and say the parent and the subsidiary conspired together to do this human rights abuse? Could you do that? And we say, yeah, that's a great idea. And we go and we research it, and then we say, no, actually, the civil provisions can't be applied extraterritorially because of RJR Nabisco, whatever. We do our sort of initial research, and then it dies in the lab. So then we have things that, if they make it out of that initial research phase, we move into a prototyping and testing phase, which might mean filing a case or getting a use case or a lot of different things, kind of what testing looks like. It's complicated, but we do try to make that test as limited as possible. So we want to just test the thing that we're dealing with, but every human rights strategy, and honestly every litigation strategy, has some common elements. We want to take as many of those as possible and pull them out so that we can test just this one really specific thing. So I'll give you one example of a test that we're working on to give you a sense of what how we're thinking of this. So do you want to go to my...
I realize
good luck
what
getting
takes
there.
so long is I have to get through my animation.
So how many lawyers do I have in the room? Okay, y'all are going to all leave as lawyers when I'm done with this really great example. But I kind of want the camera to follow me, and I'm going to come over to my slides. So everybody come with me. Come with me here.
There.
Okay, it's coming up. Okay, so I'm going to introduce to you a concept. It's called Third-Party Beneficiary Law, for anyone who's not a lawyer and is not familiar with that. So I know that you hear that term. Oh no, I'm getting too close to this microphone. You hear that term and your eyes glaze over. So I want to give you a really concrete example of what this legal concept is, and then I'll tell you how we're applying it. So let's say that Joanne, she says, Paul, all this great work you've been doing with Rights CoLab, I really appreciate it, and I want to buy you a red Ferrari to thank you, and then tomorrow I'm moving to Zambia. And Paul says, Joanne, that is so nice. So Joanne goes to the car dealer, and she enters into a contract with the car dealer, and she gives the car dealer the money. It's a used car because, come on, let's be honest, this is a very generous gift. So it gives Joanne the car. Joanne gives the car dealer the money. The contract is between Joanne and the car dealer. So there's two parties to the contract. It's Joanne, it's the car dealer. So Joanne gets the car. It's used. She gives it to Paul. She moves to Zambia the next day. And 3 days later, the car breaks down. And Paul says, hey, car dealer, my car broke down. And the car dealer says, you weren't a party to this contract. You know, why don't you go talk to Joanne? He says, well, Joanne's in Zambia. I can't go talk to Joanne. But don't worry, guys, because when Joanne went to the car dealer, she said, I'm buying this car for Paul. So Paul's an intended third-party beneficiary of the contract. He has direct contractual rights under this contract. Does that make sense as a concept? Okay, now take the same thing to a global supply chain. So we were talking earlier about codes and monitoring. So here, you've got a brand and a supplier. So we're going to say a big brand X. I won't name one because I've been sued in a slap suit before, so I don't want to get into. Okay, so big brand X enters into a contract with a supplier, and that contract contains a labor code, right? So that labor code says no discrimination, you can't fire a pregnant woman, you have to pay the minimum wage, overtime can't be forced, and it has to be compensated, whatever is in their code. They embed that in the contract with the supplier company. Now, when I say supplier, you might be thinking factory, and that's true sometimes. But a lot of times, you have a top-tier supplier who's actually buying from all the factories. And that might be a big US company, right? So you're not necessarily talking about one little Chinese factory with a contract with Walmart. You're probably talking about various other intermediate entities that might be themselves brands, or they might be a Li and Feng, kind of a middle person like that, not to be gender normative. And so I think that in these contracts, you see a lot of these labor codes which then become contractually enforceable terms, but nobody wants to enforce it, right? So when you see a violation of the labor code, does the brand want to go and sue their supplier and screw up their commercial relationship with their supplier by suing on a labor code violation? No. But what about that worker? So the labor code says that the worker can't be subject to discrimination. Well, so when the pregnant worker gets fired, are they a third-party beneficiary of the contract between the brand and the supplier? I would say that they are. And so in 2007, there was a case filed, Doe versus Walmart in California, on this very theory on behalf of 5 workers from 5 different countries who said my labor rights were violated through a labor code violation. And the court threw it out because they said, you sued Walmart, and Walmart is the one who said, hey, supplier, you need to abide by these terms, right? They were the promisee. They received the promise to abide by the labor code. And so that wouldn't work. So then it raises the question, well, what about all these top-tier suppliers? Can we start suing them on a third-party beneficiary theory where workers who are harmed get compensation through that? And does that create a more efficient mechanism going, sort of thinking back to when I was talking about organizing with flour workers in Colombia, there we would go and be like, hey, consumers, write a letter to Dole and tell them to stop busting this union. Right? Well, that was a violation of the Freedom of Association clause in the labor provisions in those contracts. So could the workers have just brought a case against the supplier saying my rights were violated? I would say yes. And so we did some research into this and learned that every single one of these contracts is going to have a no third-party beneficiary clause. And in about 2/3 of states, they will ignore that if it is obvious from the face of the contract that somebody else was intended to benefit. So I think that we could be bringing those cases. But then we thought, what if instead companies of goodwill started to add an intended third-party beneficiary clause onto their labor agreements, right? What if they just did it voluntarily? Would anyone do this? Is this a crazy idea? So we launched a test case. We found, there's some confidentiality issues, but we found a very famous nun who has a lot of T-shirts with her image and bobbleheads and socks and other things. And we said to this nun, hey, wouldn't you like to be sure that if the workers producing the goods bearing your image, if their labor rights were violated, they had some access to remedy? And she said yes. And her community said yes. And so we entered into contracts. We have 14 US manufacturers that are all US companies that are producing with our intended third-party beneficiary clause as an addendum to the labor code. We're getting factory disclosures. We're dealing with worker education issues. There's a lot of details that, in order for any worker to ever sue, which now they could sue in state court right? So this gives them access to US courts. They can sue in state court on a contract law claim. So in some sense, it's depoliticized, right? It's not a human rights claim, it's a contract violation, right? So we get to sort of transcend some of those debates, and if we get a super conservative judge, that's not gonna hurt us as much as it did in our Alien Tort Statute cases. And that would create sort of a much more efficient mechanism for remedy for workers. I know that's a little complicated and legal, but I think that we're in a space where we do need to start thinking a little bit more about the way commerce is done. You know, what are the mechanisms, what are the tools that companies use to structure their supply chains and the way they operate? And instead of staying out in our like human rights, you know, whatever world where we can be sort of soft in a lot of ways, how do we get into these like really hard details and figure out ways to change the incentives on these companies? So whether or not this could go toward mass adoption remains an open question, but we're talking to multi-stakeholder initiatives, we're talking to folks who are doing direct brand engagement to say, look, the code and monitoring system has been a huge failure. And so the CSR system in some ways is ripe for an innovation, and this is a pretty simple, elegant innovation that can be done inexpensively. And this is actually the worst part about it. The downside of this strategy is that it doesn't expose the brand to liability. It exposes the supplier. So I wish that the liability was on the brand. I think that's where it needs to be. I can't get it there right now, but that's kind of what we're working towards. But it does shift the liability much closer to an entity who is well situated to handle it, which is to say the one with the 30% profit margin and all of the power in the supply chain. Because right now the liability sits with a factory with a 1% profit margin who is very much squeezed. So that's one idea that's come out of the lab that we're working with. We're also doing some work around international trade law. We have a case that we're going to be filing at the International Trade Commission very soon, trying to fashion a systemic abuse of human rights as an unfair method of competition. So how is an ethical company disadvantaged by the unethical behavior of competitor companies? We're focusing on the International Trade Commission because they typically use, they're usually for patent disputes, and so there's a lot of benefits in that area of law. We don't have to show that they had control over the suppliers or knowledge of what was happening, which in normal tort law we do. So what you see, like the patent law regime is much easier, the burdens of proof are much easier to satisfy than they are in a human rights tort. So we're trying to sort of move around to different areas of law, see what procedural and other kinds of benefits we might be able to access and jump on them.
Can you just talk about your intellectual property work for a minute?
Yeah, sure. So another sort of thing that came out of the lab is, we started to think about intellectual property creators. So, all of us are IP creators. You're all sitting here writing on your notebooks. You're creating IP just right here as we sit. And so if that IP goes into any supply chain, you as a creator have a power. And are you exercising that power? So we're trying to think through ways that IP creators can take that power and use it for human rights and global supply chains. So we've developed a series of software licenses. So let's say you're like an open source software developer, you make an app or you make a Drupal module or whatever, and you automatically put in an open source license. We have a bunch of model licenses available, so you could either put in a license that's going to include a labor code or something simple like that. We also have some choose your own adventure, so you could do like no ICE contracts, or you could do no private prison industry if you wanted to sort of choose your own adventure. But the idea of these is that you as the IP creator, if you put this in your license and someone then uses your creation but violates that term, that condition that you put in, then you as the creator have an infringement claim against them. But don't worry, we'll put in third-party beneficiary language so that also whoever's harmed as a result of that violation also has an action against the user of the IP. Now the damages might be small, but it is a way that, if you could create if a lot of IP creators started to think of this power that they had in their licensing, and particularly in the open source world, but you could see this in, if Beyonce did this, think about the kind of power she could wield. So if you got any sort of high profile folks with really valuable IP, but then also think about it in the healthcare industry. If somebody who's creating a new pharmaceutical is going to put this in their patent, which they would need to be a pretty special person to negotiate that with whatever company they work for. But if they could put this in their patent, that might help them avoid something where there's overcharging in a low-income country for a much-needed medication. So there's a lot of applications of IP conditionality, and I really want it to take off. But right now it's kind of in this nascent stage where it's a great idea, but we need to convince people that it's a good idea. So that's another one that we're working on.
Great. Do we want to do a sort of a clip? Because, Paul, you've been thinking about technology in terms of that the leverage of financial actors and how that, because it's a
Sure.
new sort of.
So human rights violations rarely come to the surface, mainly because the people whose rights are being violated are afraid to report the violations, because very often they get put in jail or threatened with death or killed. And so when people try to think about data that connects human rights abuses to actual corporate impacts on the corporations, which is where shareholders can step in and say, we don't want your profit, we don't want your sales to go down because you had reputational damage because you committed a human rights violation. So first of all, there has to be a human rights violation that everyone knows about, and then people can get mad at the company and protest and boycott, and then the company experiences reputational damage, and then shareholders can step in and either sue or make the company change. But there's no data. But in the last 5 years, really only, the development of big data and natural language processing and machine learning has reached a point where, for example, an algorithm can scrape everyone in the world's Twitter feed and do natural language processing to say, oh, well, in these cases, when somebody in Southeast Asia is sick and has to go home, does that mean that they were injured on the job? And you can get these algorithms to learn that stuff. And then there are actually companies now that do this and then get the data and then sell it to investors. And then the investors can say, this company seems to have more human rights violations than other companies do, and so maybe we should engage with them. And so there is now technological advances that can help police corporate human rights abuses by helping bring these abuses out into the open.
Great. And of course, just before I open it up, many of you are probably familiar with the notion of using blockchain or a distributed ledger to identify the provenance of, say, commodities like cocoa or sugar, or whether they were sourced increasingly. There's projects now looking at whether certain agricultural products were sourced from lands that had customary land title and trying to identify who had rights to that land when insecure land title is such a big issue around big agribusiness. So we see tech really coming in. That's certainly something we need to keep our eyes on in the space, on the corporate accountability space. I'd like to open it up now to, as we said, a broader conversation, the last 15 minutes or so that we have. Yes, Shelley.
Do people need to use the microphone since we're recording? Oh, okay. Maybe.
Or I could repeat
okay.
the question as well. That's okay.
Oh yeah, either way. Yeah, great.
Yeah, I just wanted to pick off your last point. I mean, this was fascinating. There's so many questions. But your last point on innovations and blockchain. There's also Bitcoin and impact investing, these sorts of innovations that are trying to have social good come out of, financial. Bitcoin obviously doesn't intend to have social good, but where are your thoughts on some of these other tools and how they fit into the corporate accountability space, and then also your thoughts on the efforts to do a business and human rights treaty, and whether that will have any bite, and whether that process is worth the effort that is going into it and the investment in it. I'll leave it there. I have tons of questions. Just thank you so much. It's really interesting.
So I did say a word about the innovative ways in which blockchain is being used for supply chain traceability, and I think that's a really interesting space to watch. Would you like to say something about impact investing, Paul?
Sure, and then you should talk about the treaty.
I'm gonna.
Right.
Or you
I'm
should talk
gonna
about the
pitch
treaty.
that to-
Okay.
yeah.
So impact investing is very interesting because no one's really sure if it's going to work. And the problem is that in order to meet the SDGs, which no one's even mentioned yet, by 2030, $3 to $5 trillion in investment has to go into things like clean energy and social justice and micro lending and economic inequality and all that stuff. And right now about 500 billion a year is going into it. So, somewhere between an eighth and a tenth of what is required every year is going into it. The biggest pool of money that can be utilized for it sits with, basically with US pension funds. And they're not doing anything. And they're not doing anything because they are afraid that as fiduciaries, they're going to be investing in things that don't produce a good return. And they're not allowed to do that. What is required is a change in how we look at fiduciary duty. It's more than I can get into, but it's a project that I'm working on. In 1994, the fiduciary code was rewritten by the American Law Institute, incorporating some theories of finance that were at that time 40 years old and had been talked about in the legal community for 20 years. There are some new theories of finance that are coincidentally 40 years old and have been talked about in the legal community for about 20 years. And they are much more geared toward, what is, I don't have to maximize my return. What I really need to do is cut my risk. And if climate change is going to destroy the world, and if economic inequality is going to destroy the world, then those are risks that need to be taken care of before you can start producing a return. Once those things take place, then you can get all of this investment into projects that we know will cut risk. We're not sure will produce a return commensurate with, investing in Pepsi stock, for example. So that's the problem with impact investing, and that's a potential solution to beef up impact investing. Then the treaty, the binding treaty.
The treaty. Wait, let me say one thing about blockchain. So I just want to say, I know that there's like a lot of potential for blockchain in some respects, and at the risk of making an obvious point, the data that is entered into a blockchain system is only as good as the data that is entered, right? And the fact that it's all verifiable, et cetera, it's not verifying the underlying data, it's just that it was entered at a particular time and place.
That's right.
So I think that that's a big limitation, and also if companies wanted to have supply chain transparency or transparency around the flow of money from the rural farmer all the way through to, through the agribusiness company, et cetera, they could do that now. And so the fact that they have a technology to do it doesn't mean that they are going to do it. So I think that there is some potential for blockchain to give rise to new technologies, but the will of companies to actually do something, whether in terms of transparency or ensuring, premiums get all the way down to farmers or whatever it is, that still lies with the company. So in that sense, we're in kind of the same problem as I view blockchain, not to be a negative Nancy. Okay, on the binding treaty, I will just say that, I think that for folks who have not been following it, they released an early draft of a treaty on business and human rights called the Zero Draft, and it was pretty widely criticized. Nobody was happy with it. A new draft has come out in the last few months that is a significant step in the right direction. There is some potential for access to remedy under this treaty. It satisfied multiple parties in some respects, so in terms of it being diplomatically viable.
And was highly influenced by the new French due diligence law, right. So big
And they
advantage.
finally the first draft acted as though the UNGPs didn't exist, which was an odd move. The new draft, does even more than sort of give the UNGPs lip service. So I think that demonstrates kind of an integration of multiple movements within similar spaces, and that's helpful. There's still no outlining of corporate legal liability for complicity with state human rights violations, which is where a lot of this stuff happens, right? Where a company is using a particular brigade of the local military to protect their operations, and the military, who is funded by and encouraged to do things by the company, ends up, killing the indigenous activist that's trying to protect the land, whatever it is. Those kinds of scenarios need to be kind of spelled out clearly in a treaty like this, just because they're so common, and that is how so much business human rights violation occurs. So there's still some unhappiness. I think in terms of like whether or not, if it's really good, then it's not diplomatically viable. If it's diplomatically viable, is it ever going to offer us anything we really need? I don't know. Good question.
I'm in favor of the process.
Yeah, I think
I'm
the
in
process
favor.
is
I want to
disruptive.
see it happen.
Yeah.
I want to see it be another tool. It's tough for the corporate accountability movement because we're only so many people, right? And you can only be, and so you can't have everybody absorbed in the treaty. You really have to kind of divide. And so it's good that some people are involved. The rest of us have to keep on keeping on while that process goes forward. Yeah.
So I first just want to say thank you for being here. This is not my area of expertise, but I really enjoyed listening and learning from the three of you this morning, so thank you. Given where we are geographically, Dayton, Ohio, the Midwest, there's a lot of small business in this area. You talked about employee ownership. I'm curious what you think the role is, or is there a role that small business owners play as we move towards trying to get more consistent, better corporate accountability?
Do you guys want to go first?
Well, I would certainly say I think I have two thoughts about that. And one thing is just to note that in the UN guiding principles, because there was a big question about whether this applies to small and medium-sized enterprises, and John Ruggie was clear that it's not about the size of the enterprise, it's about the severity of the harm. So so no company, no matter what size, should be exempt from the UN guiding principles. That said, as I mentioned, I certainly think that businesses that are closer to communities, that are more integrated into those communities, have a higher chance of being sort of more purpose-centered entities than these massive mega corporations spanning the globe, the sort of anonymous. So I would tend to say that while I think that you can scale and you should scale, we should also be thinking about the limits to that scaling in terms of where do you reach a certain point? There has to be a certain point beyond which it's impossible to do human rights due diligence.
I would bring up that people are thinking hard about innovations that can apply to small business. So, for example, when a business owner is getting old, thinking of retiring, what to do with the business, sell it, or pass it down to their heirs. There's some financing that's being worked on that will allow the business owner to sell the business to the employees of the business, for example. And then the employees pay back the business owner over time. There are a lot of innovations that are being thought about in that regard. Becoming a B Corp for a small business is kind of onerous because there's all these requirements, and you have to fill out a report every year, and you might not want to do that. But there are a lot of other ways for business owners to be incentivized, small business owners, to be incentivized to act in a way that ends up with a very responsible business going forward.
And I would say, and this sort of builds on that, but I would say that small businesses, even though they exercise a lot less power in global supply chains, so, as purchasers, for example, they're purchasing these small amounts. So how much can they really influence the supply chain? think that's a valid question, but also I would like to see a world in which small businesses were kind of the vanguard. Like these should be the incubators of new ideas. How can small businesses band together and show the big companies how it can be done? And I think big companies are often arguing, we're too big, this is too complicated, we can't put third-party beneficiary language in all of our contracts because we'd have 100,000 workers that would potentially have, causes of action against our suppliers. That seems crazy. But the way that small businesses can start to use some of these tools and create use cases and create case studies so that we can demonstrate, here's how this operates. I think that's, and think about unfair competition claims, right? Small businesses are disadvantaged by the unethical business practices of big companies that are, doing such a bad job in their due diligence that they're surprised to find that some product they brought in was made in a prison labor camp in China, right? This keeps happening where even in the university market, Badger Sportswear, was that last year, was in a Uyghur Muslim internment camp, it turned out. And people had gone and visited and thought they were visiting a factory because factories and prisons look the same, right? let's just stop there for a second, right? But I think that we do have this sort of space of opportunity where small businesses need to get out of the mindset of, I don't have any power, I'm disadvantaged, I'm competing with the big guys. And how can they band together and try to make a brand or make a collective solution that really pushes back against these forces in the global economy that disadvantage workers overseas, but disadvantage small businesses here too?
And I just want to follow up on that point. One of the reasons that I see such possibilities with alternative corporate forms is because I believe that increasingly millennials want to work for these kind of corporations, right? And so that is really attracting the next generation to these smaller social enterprises. And that, if you go back to my web of corporate accountability, I think that this is going to be another lever that when you have these social enterprises that are really modeling a more sustainable, purpose-centered company, you're going to start to, hopefully that will be another lever for change with the big corporations, and we can start to see that shift.
I've been studying the social enterprise sector in Myanmar for a while, and it's a different picture in Asia to a large extent. Thailand, of course, has they have a department of social enterprise, all kinds of laws that are well developed, and they're quite different from what we've seen in the US and the UK. A wide variety of legal forms for social enterprises, in fact. And I think you're right, especially since 2008, when our graduates were not finding jobs, they were told, hey, you can go create your own job and do something with social purpose and put your mission first. And by the way, got a triple bottom line, we're interested in you can do something good for the environment too. And I've seen this become an ascending model in international development. And I think sometimes there's a spectrum of the kinds of social innovation inspiring these forms. Some look like your average business to some extent. Some are really striving to do something that might be seen as an agent of change, social change. But the idea essentially is that these are engaged in social problem solving and often hitched to digital technologies too. There's almost a technocratic ethos in this world, and that attracts a lot of impact investors, I think, who now are in a position to tell former activists and NGOs who are working on corporate accountability, it's like, hey, you all are social entrepreneurs now. You got to think more like a business. If you want our money, and you're going to get less and less from states, you're going to get more and more from us. We'll tell you which issues are worth focusing on and which issues aren't. And so I've been tracing sort of what's happening in terms of the international human rights agenda as this process starts to converge with digital technologies in being hitched to human rights science. But I've also noticed in this area of development that it's not anymore, and when I first started looking at this, it was very much about neoliberal corporate capitalism and its influence on development. And that's how I got very interested in corporate accountability. Now I find myself contending also with sovereign wealth funds from China, right? As this area in Asia is restructuring around the knowledge economy, and they're starting to drive global capitalism, global knowledge capitalism, more than we used to. They're calling more of the shots, and they're doing it through a kind of state capitalism that offers a different structure of opportunities and constraints for would-be movements that want to hold them accountable as market participants. And I'm wondering if you all have thought about that at all. I mean, you've talked about mutual funds, but sovereign wealth funds seem different. And I wonder if you can have any insights on that or been thinking about this, or is that just sort of limits and we're not going to go there yet as we're focusing on the big corporate piece?
Sounds like a Paul question.
Yeah.
No, I said a Paul question.
So it's kind of a keys under the lamppost problem because there's not a whole lot you can do with Chinese sovereign wealth funds. You can do a lot more with public corporations. Luckily, the largest sovereign wealth funds have begun to get some socially responsible religion. So the Sovereign Wealth Fund of Norway is held up as a shining example of a fund that is acting very responsibly toward its investee companies. Everyone's worried about the Belt and Road Initiative. If anyone can think of a way to impact the Belt and Road Initiative, let us know, because we're stuck. It's really a question of then how can you influence government? It's analogous to a mutual fund. How can you influence the mutual fund to influence the companies? How can you influence the government to influence the companies?
I definitely think there needs to be a fourth chair here of somebody who's innovating around Chinese sovereign wealth funds. I mean, I think that this is a really tough area, and you framed it you're absolutely right. It needs much more attention. I'm not familiar with any innovation there yet. I know some people who are looking at it though. Yeah.
And can you pass the mic over to the other side?
Maybe just.
So I had two more questions. One that stems from the last discussion, and it's around IFIs and where you think they fall on these issues and how much influence you think they remain having or not, and how much more could be done to align them to this agenda. And the second question is around the innovation and digital innovation and tech driving business innovation, the Airbnbs and the Ubers, et cetera, which have essentially, if you go back to the story, the idea was it was social entrepreneurship in essence, that this was going to unleash and democratize and empower people on simple things like their homes and how they travel, but ended up quite in a series of violations of human rights and workers' rights and other significant challenges with the way that they are running their businesses. What's your take on how that's evolved? Thank you.
I can take DFIs. Should I do DFIs? So
I can take platforms.
You want to do platforms? Okay. So on development finance institutions, in terms of access to remedy, they have a very positive role to play because they all have accountability mechanisms, and one of the best is the IFCs, the World Bank's IFCs Compliance Advisor Ombudsman. I, for 2 years, ran a clinic at Business and Human Rights Clinic at Columbia, where we were helping our client to pioneer investment chain mapping, and we would be getting requests from communities that were harmed, usually land or natural resource or housing rights violation, and we would use financial databases to map those harms and identify the investment chain, the financial actors that were involved. And if you could locate an IFC investment, and increasingly about 75–80% of IFC investments go through a financial intermediary, in other words, usually a national bank in that country, it was a jackpot, because then you could access the CAO. And if you access the CAO, you have a pretty good chance, if you've got a decent complaint, you have a pretty good chance that you can at least get your case accepted and maybe get to the mediation table with the company. And that process then, once you're in the mediation table, can go anyway, but at least you had the opportunity. If you couldn't find a DFI, and all the accountability mechanisms have them, it gets a little tougher because most banks do not have remedy mechanisms. So from a remedy point of view, they have an important role to play. But there has been this problem with this financial intermediary lending, that those IFC performance standards have not always been, in fact, in vast majority of cases, have not been followed through by, sort of in the IFC's own supply chain, if you will, have not been followed through by that intermediary bank. So there have been many, many, many more cases filed with the CAO precisely involving that intermediary bank. So that's a reform that I think is in process now at the IFC and the other DFIs.
I'll talk a little bit about platforms. Do you want to say anything about platforms?
No.
Okay. So platforms are a huge problem, and they'll be a huge problem forever probably, because almost by definition, they will be far ahead of any attempts to regulate them. Thankfully, there are some people working on the general topic of ethical digital platforms, both on the private equity side and the academic side. I can connect you to some people working on something called platform cooperativism, coming out of the New School in New York. There are also private equity groups that are, we know of one, for example, that is starting a nonprofit digital platform incubator for incubating only ethical digital platforms, and that's why it's a nonprofit. And then the person you're sitting next to can also tell you a lot about ethical digital platforms that NGOs are innovating.
Well, and maybe I'll just add to that and say that the idea of creating an ethical digital platform is great, but if you are also within the open source space, you contribute that back. So imagine like I created, let's say I think that TaskRabbit's really problematic, right? So everybody's, they're gonna say, I'm gonna do this task for you, and you get this payment, it's very small, the person who's doing the task has no power. What if I wanna create a new platform that's gonna take the TaskRabbit concept, but is gonna let people do research or whatever that task is, and give more power into the hands of the doer of the thing, right? That's great, but I'm probably gonna release this back to the open source community, and then someone's gonna take that and build it and use it in an unethical way. So I just wanna say that I think the ethical platforms are great, but you have to have IP conditionality to make it work.
IP conditionality, remember that, it's gonna be big. And I would just say, none of this stuff is gonna work in the general context of the huge power asymmetries that exist. And so it's a bigger problem.
Are we ending on that note?
It's a bigger problem than that.
Oh, I think we're over time.
Well, we are
Yeah.
over time
Yeah.
and we're moved into your coffee break, but thank you all for coming.
Thank you.
Thanks.
Thank you.
Do you think anyone got a picture of the three of us up here so I can tweet it?
We can ask,
Ed
should we
did.
ask Ed to
Ed
do
did?
it?
Okay.
Yeah.
Are you sure he did it?
Did you get a picture of us, Ed?
Oh,
Okay.
okay.
It's on Twitter? Okay, great.
Charity wants to retweet.
I know. We're like trying. I'm trying to do it. I already did. See, that's the magic that I want to be
Your
Like angels are
people.
singing.
Nothing
You
like a
just said
digital
that,
platform,
the
eh?
angels
That's
start
an IP
singing.
conditionality.
Oh, no, that's amazing. I love my people.
Do you have an answer to China?
Do I have an answer?
I really do think we turn it.